I want to thank J.D. Mack. I want to thank Beth Kingsley, the National Capital Area Skeptics, for inviting me here today. I want to thank all of you for braving the snow and coming out, and hopefully it'll be a fun talk. As you know, I'm a lawyer, so before I give a talk, got to give a disclaimer. This speech is for educational and entertainment purposes only, does not form an attorney-client relationship. Don't take legal advice from this speech. Right. With that out of the way, I know we've got some people who listen to my show, Opening Arguments, in the audience. If you haven't, give it a shot. It's not bad. I started Opening Arguments because I'm a skeptic. And here's how David Hume put it. He said, "Where men are the most sure and arrogant, they are commonly the most mistaken, and have there given reins to passion without that proper deliberation and suspense, which can alone secure them from the grossest of absurdities." And I know what you're asking. Why is there a little puppy in the bottom left-hand corner? The puppy's there for two reasons. Number one, she barks during the show sometimes, so people who listen to the show want to see the puppy. And number two, I'm about to beat you up a little bit, and nobody can stay mad at a guy with a cute puppy for very long, so remember that. Okay. Before I get to the beating up, how about a little more pandering first, right? So let's start off with some easy ones here, right? Nobody in this room believes there's a magic man in the sky, right? So, and I know we're, this is going to go out to my religious listeners as well. So I want to point out, and they hate, you got to hate the magic man in the sky language. I want to point out that if you type God into Google Images with free to use, even commercially checked, you get the first 30 images that come up are all like this. So this is your iconography, guys, magic man in the sky. Anyway, no one here thinks vaccines cause autism, right? No one here thinks the earth is 6,000 years old. No one here believes in homeopathic medicine. No one here thinks that you should insert a jade egg into your vagina to connect the second chara, the heart, with your yoni for optimal self-love and well-being. Okay, so congratulations, right? But let's be honest, those are some really, 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 really easy questions. I mean, right? But what I noticed was a lot of people call themselves skeptics, weren't all that skeptical about the law. And here's where I start to beat you guys up a little bit. Not you, because you just came in. Welcome, welcome. This front page story on the popular liberal website, I read, the Daily Kos from February of 2017. Dozens of skeptics, people who listen to my show, sent me this article and said, I'm super excited about this, and it's a story about a petition for writ of mandamus before the U.S. Supreme Court that was going to overturn, nullify the 2017 election, get rid of President Trump, hold a do-over. That sounded fun. The Daily Kos described it as a largely unnoticed and potentially landmark case. Now, again, you can see, February 12th, 2017. This was after President Trump was inaugurated, taken the oath of office, issued 3 separate executive orders. I don't have to tell you that this potentially landmark case was summarily dismissed by the Supreme Court using a procedure that didn't require the government to file a response brief, which is something that the Supreme Court reserves for their most special of crank filings. Do you think that got a full-page, front-page headline on the Daily Kos? That would be correct. But you might not be surprised to know that as of today, I pulled this up yesterday, you can still donate $25 to the organization that brought this nonsense petition, Revote 2017. And if you do, they will even send you a printed copy of the petition that the Supreme Court threw into the garbage for, I don't know, posterity or something. Right? And check out that URL. It's still active. But let me warn you, if any of you actually donate money to these charlatans, I will come over there and punch you like a Nazi, all right? Now, here's what I couldn't figure out, right? When J-Random Creationist tells you this is the bacterial flagellum and it's irreducibly complex, which means that it was specially created, your bullshit detectors go off, right? You know you are dealing with an extraordinary claim, and so what you do is you appeal to the consensus of mainstream science, right? That's how I know this is a nonsense. I mean, I'm not a molecular biologist, but every molecular biologist pretty much says that it's nonsense, so good enough for me. Same thing is true when we're rejecting Gwyneth Paltrow, and the same thing is true when we're rejecting claims by these lovely, well-meaning young men who just want to tell you the story of how ancient Israelites came over on wooden submarines to bring steel swords and horses to the Americas and write down their stories on golden plates. And I want to be clear, I'm not just hauling out the Mormons for cheap laughs, right? We know Gwyneth Paltrow is wrong because of mainstream science. We know the Mormons are wrong because of mainstream archaeology and history and genetics and linguistics and the works of Shakespeare, for a lot of reasons, okay? But somehow, when it comes to mainstream legal scholarship, well, you know, that's just like your opinion, man. So, I got my first sense of how hard this job was going to be just a little over a year ago this time. It was Thanksgiving Eve of 2016. I was out in my backyard getting ready to smoke a turkey for tomorrow's Thanksgiving. My hand was halfway up the bird. I'm coated in turkey goop, and all of a sudden, my phone starts going off in my pocket. It's not one, it's not two, it won't stop. It is vibrating constantly in my pocket. So I gotta go inside and I gotta scrub all the turkey goop off me and figure out what's going on. And I have, I'm not making this up, 238 notifications that have come through in about 5 to 10 minutes time. Emails, texts, messages. What in the hell was going on? And what was going on was this. This, I am sad to tell you, is the 2016 presidential election. We all know how it turned out. Trump over Clinton, 306 electoral votes to 232. But on this Thanksgiving Eve, the person who finished fourth in this two-person contest with 0, fringe Green Party candidate Jill Stein, announced that she was going to file recounts in Pennsylvania, Michigan, and Wisconsin. And if you add up those 3 states, you get just enough electoral votes to make Hillary Clinton president instead of Donald Trump. And I want to ask you, do you know what question was blowing up my phone that Thanksgiving Eve? Well, actually, it'd be easier to tell you the question that I didn't get. Right? Out of those hundreds of notifications and emails and stuff, not one person asked the right question. And the right question was, if the recounts are going to help Hillary Clinton, why aren't they being brought by Hillary Clinton? Why are they being brought by that crazy cat lady who wished Harambe a happy birthday? That's true, by the way. That's a question about standing. And I want you to put a pin in that because we're going to come back to it later. But I didn't get that question. Instead, I got 238 variants on this question. Andrew, is this real? And let me tell you what that sentence meant. It did not mean, Andrew, is this real? It meant, Andrew, please tell me this is real. I cannot handle the notion of Donald Trump being president. I will do anything. I will believe anything. Just tell me Donald Trump isn't going to be the president. Now, as it turns out, there is something those Stein voters could have done. Just as a mathematical fact, had they voted for Hillary Clinton instead in those 3 recount states, then Hillary Clinton would have won outright. And deep down, I've talked to a lot of Jill Stein voters. Some of them get angry after I give the speech. But a lot of them tell me they knew they screwed up. And I've had versions of this. This is a pretty much direct paraphrase from the Stein voter came up after one of my speeches and says, Andrew, I live in Wisconsin. We voted for Michael Dukakis back in 1988. Nate Silver said Hillary Clinton was up by 11 points. It was dark blue on the map. I just wanted to send a message. I'm really sorry. And that's what I think was undertaking a lot of these voters. They realized they'd made a miscalculation and they wanted to fix it. It's kind of like Homer watching the pig de resistance slip from his grasp, right? It's just a little dirty. It's still good. It's still good. It's just a little slimy. It's still good. It's still good. It's just a little airborne. It's still good. It's still good. It's gone. I know. I mean, even Homer came to acceptance eventually. So it's that moment, though, that moment when we try and convince ourselves that it's just a little airborne, that's when we stop being skeptics. That's when we want something to be true more than we care about whether it's false. So, the night before Thanksgiving, turned down the heat on the smoker, scrubbed myself clean, and went and recorded an emergency episode of Opening Arguments. I took to Twitter, I took to Facebook, and I said something that made me very, very unpopular with a lot of people who otherwise listened to my show and agreed with me politically. And what I said was this: I'm a lawyer, This is the law in Michigan, MGL 168.862. And it says that only a candidate who believes he or she is aggrieved on account of fraud or mistake can petition for a recount. And what that means in non-lawyer talk is you have to actually allege that a recount is going to make a difference in the election for you, right? For Jill Stein, she was at 1% before the recount, she was going to be at 1% after the recount, and she wasn't even arguing it was going to make a difference for her. She was saying it was going to help Hillary Clinton. That's standing. Jill Stein didn't have it. It was totally obvious to anybody who looked at the law, right? And it's totally obvious even if you don't know the law, right? Like courts don't let you come in and argue on behalf of somebody else. Courts don't render advisory opinions. They're there to fix your problem. And if you don't have a problem, you don't get to bring the lawsuit. The person with the problem bring the lawsuit. So I said that, and after about half an hour, I got contacted by a paralegal who's a fan of the show, who said, hey, I'm a member of this group called Lawyers on the Left on Facebook, 40,000 members. And I posted this argument, and I had 24 lawyers tell me, well, you're not a lawyer, so, go home. So I'm going to add you to the group, and can you come on and post the argument? So I did. She added me to the group. I went on, I posted the argument. And the admin of the group replied to the argument with, well, Andrew, as a lawyer, you know as well as I do that there's no predicting what a judge might do. So even if your argument is correct, I view this kind of as a lottery ticket, and I'm going to send in my money, and maybe we won't have Donald Trump as president. And maybe I should have phrased it. What I said in return was, I see there's the difference between the two of us. I wouldn't advise you to play the lottery either. And that ended my very short tenure in the Lawyers on the Left Facebook group. You know how the story ends, right? The courts in Michigan ruled that Jill Stein lacked standing. In Wisconsin, which has a different statute that doesn't require standing because of some weird aspects, Jill Stein's recount actually resulted in Donald Trump gaining 131 popular votes. That was fun. And in Pennsylvania, despite the fact that Jill Stein raised $7.5 million, she refused to post the $1 million bond, claiming that she represented, quote, regular citizens of ordinary means who couldn't afford it. Now, I am not going through this to impress upon you what a smart lawyer I am. It is not interesting that I got this right. It does not show that I am smart that I got this right. The dumbest lawyer on the planet could have gotten this right, okay? The only people who got it wrong were people, some of us here in this room, who really, really wanted it to be the other way. This is the disclaimer that was posted on Jill Stein's website and then taken down, probably coincidence, but after I called her a con artist on Twitter. You can see that it promises to maybe try and file for a recount and possibly use the money on it, but if not, she can use it on election integrity efforts to promote systemic voting system reform. That's an interesting use of the English language, but anyway. That means ballot access for the Green Party, okay? Now, look, somebody is perfectly within their rights to think that expanding ballot access for fourth party candidates is a good idea. I'm with you, okay? But if you donated to the Green Party thinking they were going to make Hillary Clinton president and they spent the money on increasing ballot access for their own candidates, that's false pretenses. This is from the Jill Stein campaign herself. You see that little Jill 2016 in the upper left-hand corner. This is where the $7.5 million went. Kind of, it's weird. You can see they spent $2 million on their own Green Party lawyers to do about $50,000 worth of work. I mean, yeah. They spent $300,000 on media. They spent $200,000 on staff. The $4.5 million in filing fees don't really add up. I don't. But I want you to look at the bottom of the screen. Okay, blow it up. Once the court cases have been completed, the remaining funds will be distributed to Green Party voting justice initiatives as determined by a ranked choice vote of the donors. In other words, it was a fundraiser. So, in case you're wondering, by the way, throughout the entirety of the Jill 2016 presidential campaign, she raised $3.7 million. That's 2 years. So the recount fundraiser in 2 weeks raised twice as much money as her entire presidential campaign raised in 2 years, and virtually all of it came on the backs of scared liberals who were willing to buy a lottery ticket with zero chance of paying off. And if that doesn't piss you off as much as these assholes selling magnetic bracelets to cure depression, you're doing skepticism wrong, because this bracelet only costs you $25. And each of the 160,000 Stein recount donors gave an average of $45. And look, that thing is 99% pure solid copper, right? Like, the magnets are encapsulated for extra protection. I think that one says that it's ribbed for her plate. Anyway, like, you buy this, you get a bracelet, right? The Stein recount voters got nothing for their $45. So, we've talked about the first area where people can go wrong in thinking about the law, that is motivated reasoning, right? Often in a political context. Everybody reporting on the Stein recount was reporting on it either from, we hate Trump, get him out of office, or we love Trump, he's going to stay in office. It's not unique to the law, but it's something to be on the lookout for. It's something to keep your bullshit detectors going on in the background. And here, I'm going to tease, I'm not going to get into the actual case. Episode 29 of Opening Arguments, if you hadn't listened, we revisit the McDonald's hot coffee case, and I will just tell you everything you think you know about that case is completely wrong, and the reason that it's wrong is because plaintiffs' trial lawyers overwhelmingly give to Democrats, and so Republicans have an incentive to make the public hate plaintiffs' trial lawyers, and Democrats are mostly incompetent. Anyway, the second way in which things go wrong is that the law sometimes uses a specialized vocabulary, and it can be confusing, right? So this is a short-form special warranty property deed in the District of Columbia. And if any of you are homeowners, you've signed something like this, and I want to tell you, most of this is incomprehensible gibberish, right? Like, it is the witnesseth the party of the first part hereby grants unto the party of the second part. Like, that seems like crazy ye olde English, right? But there's a good reason for, there's an incredibly stupid reason for this, right? And the incredibly stupid reason is that real property is mostly a common law doctrine, and so almost all of it dates back to serfdom in 13th century Saxony, and so they still use the witnesseth and the weird words, okay? So I can understand that sometimes to people it seems like the law is a bunch of crazy magic words, most of them in Latin, and you need a wizard to put them all in the right order, right? I see this in my day-to-day job all the time. I represent entrepreneurs and small businesses, and the number one thing the cash-strapped small business does when they need to have a contract with one of their vendors is you go online, you download a contract, and you do a global search and replace, and you replace ABC Corp with yours, right? And the problem is they think they're doing that because the contract contains the magic words, and now they've got the magic words, and they put their name on. But a contract is really meant to express the intent of the parties, and if you don't know what your document says, it can really, really hurt you. The point of the law, almost always, is not to get the specialized words right. Now, again, I'm not going to lie to you. There's some of the work that I do on a day-to-day basis that does require specialized vocabulary, but it's so much better now than it used to be, right? Right before the 20th century, up to the early 1900s, we had something called the forms of action in this country. And what that meant was, even if you were 100% correct in a claim against someone, you had to plead your claim in the exact right way, in the exact right order, using the exact right words, in the exact right court. Otherwise, the court would say, no, sorry, get out. And so you have these things, and I got to read these. A writ of right, an assize of novel desaison, or of mort de ancestor. I think I know what that one is. A writ of entry sur desaison in the per and cui, a writ of besail of quare impeded, an action of covenant debt and you replevin trespass assumpsit ejectment case. I do not know what almost all of those words mean, and I don't have to, because about a century ago, all the lawyers got together in this country and we replaced all that crazy Latin crap with that sentence. There is one form of action, the civil action. And the rules are meant to be liberally construed. So you can, and I'm not making this up, you can take a napkin, you can take pink nail polish and write Andrew owes me money in pink nail polish on the napkin. You can misspell money, and then you can take it down to the courthouse and give it to the clerk, and they will date stamp and file your napkin, and the court will take it seriously. So, understand that the thrust today is away from specialized vocabulary and magic words. Not 100%, but if you're looking at an argument and it seems like it requires the right words in the right order, be a little bit skeptical about it. Third area where people go astray in the law is ambiguity and equivocation among legal terms. And strap in, because this is where it gets weird. This is a Louisiana birth certificate, but most state birth certificates look like this. You will see on that birth certificate that the last name is listed in all capital letters. If you're a sane person, that's because government documents were standardized at a time when typewriters didn't have lowercase letters, right? If you're a crazy person, that's because capital letters represents a straw man, a kind of shadowy corporate entity that sounds like your name, but is really a corporation that was created by the state. And everybody is tricked from birth into linking you a real, free person with this shadowy corporate straw man. So, my name, as it appears on my birth certificate, Philip Andrew Torrez. But if I were a sovereign citizen, I would start spelling my name this way. And you see, by putting the symbols and the spaces and the lowercase letters all there, that means I've created a legal distinction between Andrew Torrez, the person, represented by the symbols at the bottom, and Andrew Torrez, the corporate straw man, represented by the all caps name at the top. All right, so we had a bunch of goofballs running around spelling their names with brackets in it. Like, who cares, right? Turns out sovereign citizens do a little bit more than just spell their name strangely, right? Oh, this is a screenshot from a website called UnitedTruthSeekers.com. It's in the. I actually cut down most of the purple so that nobody would have a seizure here in the audience. But this is a real screenshot here. The argument is your birth certificate shows your name in all capitals because it is really a negotiable instrument. You see, when the United States went off the gold standard in 1933, it declared a double secret bankruptcy. Because you didn't have gold anymore, the government had to go out and pledge its citizens as collateral to a shadowy cabal of international bankers. That means Jews. And so that's what your birth certificate is. That's the negotiable instrument that shows you're pledged as collateral to the international bankers. And if you sever the link between you and your straw man, you can access that account and get your hands on that sweet, sweet Jew gold. Now, this is my favorite thing. Right now, notice that it said your birth certificate's worth billions. I gave a version of this talk in Australia, and a listener came up after the show and pointed out that in the lower right-hand corner of this website, which teaches you how to access billions of dollars from your birth certificate, it says the website is brought to you exclusively by member donations so that you can help pay the rent. So, all right. Look, we've had a good laugh, but tens of thousands of people, maybe more, actually believe this. It's enough that the FBI has issued a scam alert. It's enough that this cost the IRS hundreds of millions of dollars in order to try and enforce it because people file zero tax returns and all sorts of other crazy stuff. How can this possibly happen? How can otherwise well-meaning people think that their birth certificate is a secret key to a bank account held by international Jews? Obviously, there's some motivated reasoning going on with the billions of dollars. Obviously, there's some magic words, but the real heart of this scam is the third bullet point, which is ambiguity and equivocation. Real citation, Black's Law Dictionary, 2nd edition. This is archaic, but real. You could actually find this book. Capitis diminutio maxima is defined as the highest or most comprehensive loss of status. This occurred when man became a slave. It swept away all rights of citizenship and all family rights. Real citation. Sovereign citizen interprets that as Black's Law Dictionary explains, when you capitalize the letters in your name, you're volunteering yourself into slavery. Now, I swear I'm not making this up, this entire argument is based upon the fact that the Latin word capitis looks a lot like the English word capitalization. That's it. So, who's ready to start spelling their name in lowercase letters with crazy... All right. If you didn't buy that one, I get another argument for you. Go back to your birth certificate. If you look down at the bottom, you will see your birth certificate says it's a banknote. Isn't that good? Well, actually, it says American Banknote Company, right? And kind of like how AT&T stands for American Telephone and Telegraph, even though they're an internet service provider and there aren't any telegraphs anymore. The American Banknote Company is a subsidiary of global conglomerate AB Corp. American Banknote started in 1795. They produced the world's first tamper-resistant paper. So our nascent country engaged in a contract with American Banknote Corporation to produce the paper that was used on the money. and then treasury bills, and then when birth certificates came along, on birth certificates. So that little American banknote corporation at the bottom is about as significant as if it had said International Paper, or Kimberly-Clark, or Boise Cascade. Just the person that makes the paper. But that does not stop this guy, Judge Navin Chandra Naidu. That is not a title, by the way. He just named himself judge. It's kind of cool. For the low, low price of $250, Judge here will issue you an international bill of exchange, which he's totally sure banks are going to honor, and let you draw at least $2 million per year, tax-free every year for the next 50 years. I kind of like the at least part, right? Like when I go to the ATM, I ask it for at least 20 bucks, and sometimes it kicks out of 50, you know. No. Again, we're having a laugh, but there's a real danger here as well. And the reason is, one of the principal beliefs of sovereign citizens is that once you've delinked your straw man from your real man, then the laws literally do not apply to you anymore unless you want them to. Okay? And so what that means is that when a subpoena to show up in court shows up, it has your name in all capitals, and they say, that applies to the corporation. Hope it shows up. And so the corporations, when they do show up in court, it means that they show up under protest, often under a bench warrant, often in chains, and they are held before the judge, and they plead all their crazy sovereign citizen crap, and they lose because, of course, they lose because it's crazy, but they're sitting there, and in their world, everybody else is the person that's crazy. They've uttered the magic words. They should be free to go. And the judge is saying, no, I'm sorry, you still have to stay here, even if you're the free man and the corporation is. And so they think that it means that law enforcement professionals, that judges and cops are the ones violating the law. This is a real document, a real motion, filed in a case called Cunningham versus Canada. And it says, I've tried to use administrative procedure against these criminals. And again, by criminals, he means judges. But they don't get the message, so this is the message. If they want to perjure their oaths of office and engage in treason and sedition, they better be prepared to go all the way and murder me as well. You look to the bottom, I shall exercise my God-given right to resist their unlawful arrest with lethal force if necessary. So, how do we get people off the road that leads to them threatening to murder judges in open court? For starters, to let people know that they should instantly be suspicious of any argument that depends on a citation to Black's Law Dictionary or any other dictionary. Look, that's not to say that lawyers don't cite to dictionaries from time to time. We do. But by and large, if we want to illustrate a principle of the law, we're going to cite to a case. And we're not just going to cite language out of context from the middle of the case. We're going to tell you what the case was about, who were the parties, what did it mean, what was the holding. Okay? You see a bunch of words kind of crammed together, probably not dealing with a great argument. But I have to confess something to you. Even if you're looking at cases, you might not get the full picture. And the reason is because information about it is incompletely available, potentially misleading. Here's what I mean, okay? This is one of the most infamous cases in all of U.S. law. This is Plessy versus Ferguson, which I hope all of you recognize as the case that held that separate but equal accommodations for African Americans was legal in this country, one of the most shameful decisions in our nation's history. And famously, it was overturned by Brown versus Board of Education in 1954, so thankfully it hasn't been good law for 6.5 decades, right? Caption on the left is what you see when you type Plessy versus Ferguson into Google Scholar. The caption on the right is what I see when I type Plessy versus Ferguson into Lexis, which is a tool that I have to pay for and which pretty much only lawyers and law students have. Okay? Who of the eagle-eyed among you in the audience can spot the difference between these two citations? Right, mine has a giant red stop sign on it, right? And the reason it has a giant red stop sign on it is in case I've forgotten how to read, they want me to know, Andrew, if you cite this case in a brief, opposing counsel and the judge and all of her clerks will all laugh at you because this case hasn't been good law for 6.5 decades, right? But your citation doesn't have the little stop sign on it. There's nothing to tell you that it's not good law. Now look, pretty much everybody knows that Plessy v. Ferguson is not good law and can't be cited. I mean, except for Attorney General Jeff Sessions, but that's another story. But some of you may know that I recently engaged in a discussion on my show with a layperson regarding Ann Coulter's speech, planned speech at the University of California at Berkeley. And this guy kept citing to a Fifth Circuit case that had one of these little red stop signs on it. And I realized he didn't know it had one of those little red stop signs on it. And also, he didn't know that the Fifth Circuit covers Texas, Louisiana, and Mississippi, and not California. And also, he was citing to a dissent. You guys know that dissent is the side that lost, right? Anyway, the point was, this taught me a really valuable lesson about how people, lay people, tend to argue about the law. And what that is they take the proposition they want to be the law, and they type it into Google, and they search, and they wait to see if a case pops up, right? And then if it does, they cite that like it's an authority, even if it's not an authority, even if it's from the wrong circuit, the wrong court, in a dissent that's been overruled, right? If this were science, you would all see the problem instantly, right? You don't start with your conclusion and cherry pick to find the data to get there. But again, because it's the law, it's just your opinion, right? So you have this situation where people are relying on expertise that they don't realize isn't expertise. What can you do? It's tough. And I want to give you a little bit of a secret here. Wikipedia isn't terrible for defining principles of the law. I have a suspicion about this, and I think it's because lots of lawyers are editors on Wikipedia and we're pedants, right? And so all the stuff that's totally crazy gets edited out. So I always suggest to people, try and figure out what the general principle of the law is first. Have that, you'll see cases come up again and again, and then read the cases. Now look, is that a substitute for talking to a lawyer or listening to my show? It's not, but it's a lot better than just typing something into Google and hoping that it's true. Last one, and I know I'm running at some length here, so we'll go pretty quickly for it. Sometimes the law leads to counterintuitive results. We then tend to magnify those counterintuitive results in terms of their importance. What does that mean? If you've ever watched a cop show or attended a movie, you know about the damn technicality, right? That is, it's clear, everybody knows the guy did it. They show you the guy doing it at the beginning of the movie, but for whatever reason, you can't arrest him, you can't convict him because of that technicality. Now, this is, by the way, when you type in law technicality, you get 87,000 pages like this, right? It is a common news trope because it has that emotional and narrative power to us, right? But as it turns out in the law, technicalities are really pretty rare. And usually, when there's a technicality, there's a good reason for it, okay? And I'm going to give you an example from my area that seems like the most arbitrary of technicalities. I'm going to tell you the good reason for it. That is statutes of limitation, okay? Nothing could possibly seem more arbitrary than the rule that says you have to bring your claim within 2 years or else it's out. That means same facts, I file in 24 months, court says okay, I file in 25, court says go home. How can that be fair? Well, I'll give you a real world example. I have a client who's an accountant, okay? And he had a client who got mad and found a lawyer who wrote a nasty threatening letter that said, I'm going to sue you, because you, and so then my client, the accountant, came to me and said, can you write back and respond to this? And so I wrote back to opposing counsel and I said, well, you're wrong on the facts and you're wrong on the law, and here's what it actually is. And let me tell you what doesn't happen in those cases. What never happens is opposing counsel never writes back and says, gosh, Andrew, thank you so much. We're going to go away now. Right? What happens is they just go away. I mean, most of the time they just go away. Sometimes the second client is so mad that they find a dumber lawyer and they write another letter, right? So now in that interim period, when my client calls me up and says, hey, Andrew, remember when I paid you, a certain amount of money for you to write this letter and make this thing go away? Has it gone away yet? The answer I got to give him is, kind of, man, like he still has to prepare for the eventuality that he might be sued, right? And the only way we're going to know that he's not going to get sued is once 2 years have elapsed and the statute of limitation kicks in, okay? It provides finality for all litigants who are under a cloud of potentially being sued. And imagine, just think back, imagine if somebody could take a transaction you engaged in 12 years ago and file a lawsuit about it, right? It would be impossible. So something that seems kind of crazy on its surface, seems arbitrary, seems like a technicality, actually has a really good reason for it. If you're listening to an argument that's based almost entirely on technicalities, you're probably not listening to a good argument. And that's the point of this story. This is a case I litigated for 8 years. That in the upper left-hand corner is the First Mariner Arena, what was, now it's now the Royal Farms Arena in downtown Baltimore. Those billboards right there are there because of me. And the gravamen of the case was the law allowed my client to put up the billboards, but Peter Angelos, the owner of the Baltimore Orioles, didn't like that. And he filed a lawsuit. And basically the line, I'm simplifying, but basically the lawsuit said, yeah, I know the law lets him do it, but it's not fair, right? You may remember that I said this was an 8-year case. There were 3 separate collateral issues. I litigated it all the way up to the Court of Appeals of Maryland, which is our state Supreme Court, on 2 occasions and almost a third, all over the question of, is it fair? I could not go into court and say, Your Honor, I don't give a crap if it's fair. The law says we can do it. I had to persuade multiple courts at multiple levels, not just that this was the law, but that it was fair. And eventually we won after 8 years. Didn't matter that I was technically correct from day one. Highest court in the state was not going to rule in my favor until they were convinced that it's fair. So when you see an argument that rests on a technicality that seems unbelievably unfair, probably not a good argument. So, these are my 4 takeaways for how you can become a more skeptical consumer of the law, of legal news and claims. Number 1, try and be aware of your own biases so you're not engaged in motivated reasoning. Number 2, look for the context and try and understand the general legal principles. Don't be swayed by, isolated quotes and random cases, worse, or dictionary definitions, citations from the 1634 version of Black's Law Dictionary. Number 3, recognize that the law is moving away from technicalities and the courts will always ask, is this fair? And number 4, read the source documents. And I suppose I should put in a plug for number 5 as well, which is listen to my show. So, thank you very much. I know we had a couple questions, so.
What you were talking about when you mentioned the word sovereign citizen, it made me think back to a group in Texas. There are some people who live in Texas who believe that Texas is a sovereign, independent country. They don't have to pay taxes to the federal government.
Right. These go to court on a daily basis, right? Like the primary motivation that people get involved. I wanted to bring out some of the truly hilarious crazy on this, but the primary motivation that people get involved with this is because they get suckered in. There's a guy named Irwin Schiff.
Yeah, I remember that.
Yep.
He went to prison.
Yeah, he went to prison, but people think that's part of the conspiracy, right? Right? And he counseled people on how to avoid paying taxes. That is the primary. And look, nobody likes paying taxes, right? So people get suckered in with that argument. The Texas sovereign nation is a good example of the stop sign problem, because what they cite to real treaties and laws in our nation's history. They just don't know that those treaties have been superseded, right? They have been valid for 200 years. There's a group, I talked about this in Australia, there's a group called Free Men on the Land in Australia that are literally, they're citing to a provision in the Magna Carta, right? And they're citing to a provision in an interim version of the Magna Carta that allowed 20 landed noblemen to gather together and suspend the laws in a particular area. And so they honestly think, and I'm not making this up, they think if they get 20 people together, right, they get a room like this together, you can suspend all the laws as long as you get 20 people to agree on it. So it's pretty amazing. Yes, sir.
I know we fought the Civil War, and historically that pretty much ended it. You can't leave the Union. But on a legal basis, I've heard arguments where states voluntarily join the Union, they should legally be allowed to voluntarily leave. What's the legal basis for states not leaving the Union? Yeah. Is there one?
So let me give you 2 two answers to that question, right? So the first answer is the practical answer, right? Which is the barrel of a gun, right? But the right, right. But the second answer is sort of requires delving into social contract theory. So if you think about like the fundamental social contract theory that was put forth by John Locke, which is the basis for most of the Founding Fathers' beliefs, the idea is you can have a kind of one-way consent, right? Like, because that argument is just the, why can't I opt out of the social contract writ large? Like, at what point do we convert the fact that we think everybody's mostly voluntarily here into, yeah, now we're all here, it's a mutual pact, and you can't get out. And so that's, if I were dealing with that from a legal perspective, right, I mean, I would first say, this is an academic argument because, you know, the guys with guns are going to show up. But secondly, like, I think there are really strong social contract principles that say, right, it's the same reason, it's an extension of the reason of like, well, and I had somebody ask me this who said, well, I was born in 1979. Why should the Civil Rights Act of 1964 apply to me and my business? Right? And the answer is a kind of ongoing ratification, and you're a part of a system that benefits from that overall structure that's taken place. And that I think kind of gets to the heart of the states, right? Like when you look at, for example, tax allocation dollars, the states that yell the loudest about taxes in the federal government are almost always disproportionately recipients of federal tax dollars rather than contributors, right? You look at the largest disproportionality, like Alabama, Georgia, Mississippi, Louisiana, are the states that receive disproportionately more federal aid coming in than tax revenue they send to Washington. And so I think that kind of provides the philosophical justification.
One of the arguments that was made, I think, at the time of the Civil War was that maybe the original colonies could leave, that those states that were formed out of territories belonging to the United States could not. Yeah. Because that had been United States territory and was never independent at any time.
Yeah, there's a pretty, oh, hold on, there's a fairly lengthy history in the congressional record. The leading proponent of the states' rights theory was John C. Calhoun. And again, totally wrong in every conceivable way, but he articulated a lot of that. So if you're interested in the issue, look up Calhoun's speeches. All right, well, thank you very much. I really appreciate you coming out in the snow.